let's get started with today's presentation. Firstly, welcome everybody back for 2021 and our first webinar for the year on alternate trustees and event-based trusteeship. Today I'd like to welcome along with me Carl Rayner, who is one of our client managers here. Welcome, Carl, to today's presentation.
Thank you, Tim. It's great to be here and looking forward to it.
Okay, so what we want to do today, and this is one of those subject matters that's really pretty practical in the sense of the conversation piece. So what I want to work through is a number of elements of the presentation and ultimately get to a point where you're all comfortable that if you've got any questions or any scenarios that you throw them up in the Q&A box and we can attempt to address them as we go along. You'll all get a presentation or copy of the presentation with your CPD after the presentation. So just sit back and enjoy the next 60 minutes, and we will hopefully answer all of your questions. And of course, if you've got no questions, well, thankfully I've got 20 odd years of dealing with SMSF trustees and all the shenanigans that they can get up to. So I've certainly got a fairly large repertoire of client stories that we can work our way through. So what I want to discuss today, or what we'll be discussing today throughout the presentation at various stages, is the role of the enduring power of attorney, because it's one of those documents that for us as administrators, us as trustees, us as advisors, accountants, auditors, it means a lot from a point of view of being able to identify that somebody has one. And then from there, what it actually means in a practical sense with regards to appointing trustees. And it's always been an interesting point for me that when talking to people about setting up self-managed superannuation funds and running trustee-based presentations, the number of clients that don't have enduring power of attorneys, I suspect is relatively high. And just I gauge that from the conversations that I have. And to me, it's almost as critical, if not as critical, as having a trustee in an SMSF, because ultimately what we're going to talk about today is events that in many respects you don't know are coming. And if you are not prepared for those events, then it can be problematic from an SMSF point of view. So the role of the enduring power of attorney in SMSFs is really a theme throughout the presentation, albeit that will address a whole heap of other instances and inferences as we go along. How a fund can have more or less trustees than members based on circumstances, and that's as long as that's been around for, it still confuses people, because we have a definition of a self-managed super fund, and I will run through that definition in a moment. It still creates confusion, particularly around incapacity and death benefits with regards to membership versus trusteeship. And of course, I think how intergenerational SMSFs must factor in life events. That to me is one of the key takeaways from today, is that that events such as new family members joining, marriage, separation, obviously incapacity, death, all these sorts of things, particularly if we go down the path of 6-member self-managed superannuation funds, when we're sitting in an environment where 90-odd% of self-managed super funds are 1- or 2-member funds, we see that there is a general interest in the concept of 6-member funds, but that same general interest exists for 3- and 4-member funds. The real question comes about from, is it actually worthwhile adding more members to the superannuation fund? And that to me is one of the key issues that's critical in this conversation piece around alternate trustees, because primarily when you've got more people involved in the decision making, you've got greater scope for disagreement and therefore longevity in the capacity to make decisions. So all these sorts of things are fairly important. And of course, some things won't work in practice, which in many respects is a little bit linked to that intergenerational commentary, but also same with the enduring power of attorney and multiple trustees. In many respects, it's about identifying what is best for each set of clients to determine how are you going to make this fund equally operative or even better from an operational point of view if an event occurs to one of the members of the fund. So what I wanted to, I guess, initially introduce is some concepts that we're all fairly well aware of, but I think it's important to work through them from a SMSF definition point of view, just to identify some of the key sort of elements of the definition, but also where we're dealing with self-managed super funds, where there can be problems occurring. And of course, the first thing that we always talk about in the SMSF space is the whole corporate versus individual trustees. Now, I'm just going to throw to Carl, because we have a direct trustee offering, or we have a large number of direct trustees, and Carl's actually our client manager who deals with the largest proportion of direct trustees. And Carl, we were chatting beforehand about whole corporate versus individual, and you were giving me a few examples of the questions that you get and when people tend to raise these issues. So do you want to just give me a bit of an overview of some of that commentary?
Yeah, of course, Tim. So one of the biggest questions we get from our direct trustee clients on the corporate versus individual is the differences between the two structures and when they may or may not be suitable. So a lot of the times we're talking around if clients are looking at property investments and they want to take out an LRBA. Otherwise, we may be leaning towards the estate planning purposes, which I believe you'll be touching on as well. So it does come up as our number one question around trusteeship. Yep. And it comes up probably every week, I'd say, from new clients and existing clients as well, when they've got certain events such as death or wanting to bring in different members.
Yeah, look, and I think that's the key, is that we probably, many of you on the presentation today would have had that conversation numerous times around individual versus corporate trustees. And I think one of the key conversations, and one of the things that I discussed with Carl about with these trustees asking the questions is not only do we give them the pros and cons of corporate versus individual, but we also need to introduce the practical elements, and that is the recognition that from a corporate trustee point of view, you're not just dealing with super law, you're dealing with corporate law as well, and you're dealing with not just a deed but also a constitution. And I think that is very relevant in the whole piece around alternate trustees and event-based trusteeship, is that, you know, circumstances may not provide you with a lot of time to act, and so you need to be prepared and have things in place so that when an event occurs, you can follow the constitution, the deed, the laws, and all the other elements as required. So I think that corporate versus individual is a key message that we still need to keep producing. And it's good to see that the ATO's statistics continue to reiterate that corporate trustees are the number one sort of trustee structure in the SMSF space. Many of us would remember that a number of years ago, the ATO used to report in the negative, or they reported incorrectly, and then they sort of said, whoops, we got our reporting wrong. And the industry kind of felt that, gee, it was an over-representation of individual trustees given everybody's recommending corporate. But then the ATO said, yeah, our numbers are wrong, and actually there's more people with corporate than individual. So that's a good thing to think through. But of course, then the other key thing, particularly in this alternate trustee area and environment, is the definition of a member. And whilst the membership definition is a really relatively clear one, it does still have some elements that I would suggest are not so clear around what a member is, because it talks about somebody with accumulated benefits, but it then also talks about somebody with an entitlement to receive an income stream. So the concept of an entitlement to receive an income stream does talk about existing pensioners, but it also can talk about reversionary pensioners. It could also mean children who are under the 18 who are listed as a beneficiary of an adult parent and be in receipt of the pension if the parent passes away. So this additional membership category, which you can classify almost as the nil balance member, it's kind of, I'd say it's controversial to an extent without being outwardly controversial, and that I've always taken great comfort, not great comfort, but I've always taken an element of comfort that if you have a nil member balance because there is an intention to contribute or to commence that pension, then that's not such an issue. But if you've got someone that joins a fund on day one and calls themselves a member and for the next 30 years doesn't have any money, then I would consider that to be a little bit more dubious, particularly if we're talking about a fund where you've got one member with all of the money and 2 or 3 nil member balances. I think there's scope to say it's okay if you've got one, but the broader you make it and the more family members you bring in with zero, I think you're pushing boundaries. I've said it for a long time now, and maybe one day it'll come true, that I expect maybe the ATO will do a review of funds versus membership and actually ask some questions. And maybe they do that, and I just haven't necessarily seen it. But the member definition is a critical one. And the other one that I'll put there is non-member spouses. And I'm going to touch a little bit on marriage breakdown and separation a little bit later as well. But the interesting part of the non-member spouse is that they effectively become a member of the self-managed super fund once you've got the court orders or the operative time to engage with the superannuation agreement. But then the definitional side of things, so the fund's failure to meet the definition of a self-managed super fund is a little bit flexible when it comes to separation of non-member spouses, because normally when you add a member to a super fund, you have to add them as a trustee immediately, right? So you don't really have this 6-month rule to make the definition equal out. But if there's a non-member spouse that joins the fund, then the fund doesn't need to add them as a trustee until that 6-month period. So it's one of those little anomalies in the adding of a member. And of course, what we do understand or appreciate is that most non-member spouses don't exist in the SMSF environment, because more often than not, you've got a couple in a fund and then a separation will exist. And so you've already got the member and the theoretical non-member within the same entity. So all relevant points for us to contemplate with regards to the definition of a member. And I guess then going, without getting into too much depth, the definitions of relatives and the definitions of employees, they become critical with regards to who we can appoint as the alternate trustees for self-managed superannuation funds and who we can't. So in certain circumstances, we obviously can't appoint an employee, but then the expanded definition of who isn't an employee as well as who is gives us some form of capacity. But also, you know, if you put the link between related party transactions and the definition of trusteeship, you want to avoid adding people to the fund who might compromise investments of the fund by becoming related parties. And I've always sort of gone down that path when talking about business associates to indicate that if you've got two business associates who aren't related by anything else other than working together, then by putting them in the same fund as members, or by bringing one in as a director of a corporate trustee, then you're compromising a lot of the other entities that they might have, the business operations they might have, and creating, I guess, creating issues for the fund at that point in time. Did I just see, Carl, a question pop up?
Yeah, we do have a question here, and it was to do with that nil balance membership that you were talking about.
Yep.
So the question we've got here is, can an elderly couple have their adult son as a member of their fund with a nil balance?
Yes, it's an interesting question. I guess I kind of answered it before, but I sat very firmly on the fence. I do like to sit on the fence occasionally with these sorts of questions. I would argue that there is nothing that prohibits that, because as long as the adult son has the capacity to make contributions, right? So if the adult son is, let's say, under 67 years of age, and has the capacity to make contributions, then it means that they can be an accumulating member. Clearly, there's less likelihood that that individual is going to be in receipt of a pension, unless, of course, they suffer from a disability. So you would assume that it's more going to be around the accumulation piece. I think it's one of those areas that if that's currently the situation that they've got and it hasn't been questioned to this point in time, then I'd always say to people, be prepared. Be prepared for that moment that someone might ask a question as to whether this person is a genuine member. But I think the legislation now does provide that scope, albeit that it can be a slightly dubious area to be mindful of. So look, I think it is one of the things that we do need to take into consideration. So look, all of that, trustee remuneration, disqualified persons, I'm going to touch on disqualified persons as we go through the presentation. So just looking at our trustee dynamic, what we know that sits quite well is the number of members versus how many individual and corporate trustees. And of course, if we do have a one-member fund, we must have 2 individual trustees, otherwise a trust doesn't exist based on the definition of what a trust is. But if we've got a corporate trustee, then we can have 1 or 2 directors, obviously the member being 1, and another person who is not an employee of that person can act as the second director. And I kind of want to highlight here that I've always kind of, I guess you could say, I say it in a joking kind of manner, but I talk about the ultimate nature of single member sole director companies, and that is how awesome they are because no one else is involved in the decision-making process. And they are awesome, but they're only awesome if the member's awesome. Right now, there's different definitions of awesome. Now, what I'm defining here is clearly that they've got, they're in good health, right? They're in good financial state, as in they're not likely to create any issues from a disqualified person point of view and all those sorts of things. Then in that scope, the whole idea of a sole director company is awesome. But as we talk about a little bit when it comes to death, we need to understand that we've got rules around corporations, and you can't have a company without a director. And so once a member has passed away, then you've got to make sure that you can fill that gap relatively quickly to keep the fund operational. So again, it's always about planning and making sure that we have the right set of circumstances in place. And another question's come through there, Carl?
Yeah, we've got another question here around moving overseas for more than 2 years. So the question here, I believe you'll be touching on that topic later on, so we may look at reserving that if you'd like. Or...
Oh, no, look, I'm always keen to see how we go as we wander through.
All right, we'll jump into this topic. So question here is, if a member wants to keep an SMSF moving, but they're going overseas for more than 2 years,
yep,
what are the ways they can keep the SMSF if it's possible?
Yeah, look, it is a question that I have addressed for the presentation, but it's a great question to ask. And there are multiple ways. The main way, or the simplest way, is, or maybe not the simplest way, but if you've got 50% of members and trustees in Australia and 50% overseas, then that satisfies the definition for the central management and control point of view. You're always going to have contribution issues, so you need to make sure that non-resident members don't have more than 50% of the fund balance if they're contributors, right? So you've got your active member test requirements to be mindful of. But if you've got, let's say you've got parents and kids in a self-managed super fund, I know that it's not a standard type fund, but if you've got 2 kids overseas and 2 parents here or vice versa, then you're going to meet the definition. So that's a simple way, is 50-50. The alternative way to look at it, or one of the alternatives, probably there's 2 more alternatives to look at, is that you can appoint an enduring power of attorney to replace you with the trustee, and we're going to touch on the enduring power of attorney and how that works. So I will move that towards the second part of the presentation. The third option is just to move to a small APRA fund. And I'm going to talk about small APRA fund. I'm not too precious in that I won't talk about the alternatives to self-managed super funds. And I think small APRA is certainly an option there, particularly for when you get around, and I've done some numbers previously, once a fund balance gets up around that $500,000 in the SMSF space, then from an admin versus trustee fee, it can become competitive. Like the trustee fee can become competitive for small APRA funds, and so I think that people need to clearly look into small APRA as a viable option. And I'm actually going to come back and talk about small APRA a few times throughout the presentation, primarily because I think it is a long forgotten concept in what is, to me, a very vital and viable part of the industry, which is aged care and all those sorts of issues, and elder abuse and things where we need to be mindful of. So we'll come back to that. And of course, the final option is obviously that you roll your money out of the self-managed super fund. We're trying to avoid that from a conversation piece. So if we look at it, and this is really where we get into where the rubber hits the road about the various events that are going to occur and who our replacement trustees can be. And so we've got legislation, section 17A, paragraph 3, which provides us with alternate trustees. Now the key here with these alternate trustees is that the legislation provides for our normal SIS definition: all members must be trustees, all trustees must be members, and you know, never the twain shall meet type concept. But then typically the way that the SIS Act operates is it then provides for our exceptions, or our exceptions to prohibitions and all those sorts of things. And so what we have is what I call the may concept, and it provides that the trustees, or that the fund may appoint alternate people under certain set of circumstances. So whilst we'll work through these as we go along, death being an event that will occur in well, let's say 100% of self-managed superannuation funds, and you've got the legal person or representative who can be appointed at that point in time. And so the reason I use may is it's going to be based on the deed, it's going to be based on the existing parties as to whether or not anything's going to occur. So we need to be mindful of that. We've then got legal disability, and legal disability comes under two definitions. I've listed it under the mental incapacity one, and then as an under 18 from a minor. And once somebody's under a legal disability due to, say, mental incapacity, then their legal personal representative or their enduring power of attorney can be appointed as the replacement trustee. Now, in most set of circumstances in the SMSF environment, we will see the enduring power of attorney being appointed. Again, hence why it's critical to have such a document, is to know who's there to make decisions on somebody when they've got no capacity to make decisions for themselves. But it's, whilst slightly less common, it still exists where you might have a court-appointed legal personal representative to take care of somebody's circumstances in the event that they lose capacity. And of course, then it's a matter of saying, okay, well, if they're going to be in the self-managed superannuation fund, is it appropriate to have a self-managed super fund in that event if you've got a party that's totally unrelated to the member acting as their trustee? You know, do they really have a good history or understanding of that person and their needs and wants, on one hand? On the other hand, that alternate trustee may actually have the legal and financial and investment nous that a family member quite possibly doesn't have, and they may actually be a more appropriate trustee of the self-managed super fund because they're undertaking all of the requirements. So the legal disability being one key issue there. The granted enduring power of attorney. So this is the quirk in the legislation that says if you've got an enduring power of attorney, then that person may replace you as a trustee of the fund. And we'll touch on that when I go through the EPOA in a moment. Children under the age of 18, so they can appoint their parents or guardians or their legal personal representative. Now, again, 99% of the cases, that's a stat I made up just then, will be the parent, but in some circumstances there might be an LPR appointed for the children. But if we assume that it's going to be the parent, then which parent? You know, which parent are we choosing? How many kids are there? And so this all feeds into the conversation around multiple member funds and larger funds, and who's the appropriate party to act. And I'll talk about the idea of single parent, multiple kids, or multiple powers of attorney, single member, and all those sorts of things as we go through. Now, one of the main changes to this legislation over the last 20 years has been around that under 18, and that is that previously you had to have individual trustees, and the parents could act as a replacement trustee for individual trustees. And then eventually the law caught up with the concept around corporate trustees, and the parents can also act as director of the corporate trustee. So it's a key issue there. So they're the legislative alternate trustee options. I wanted to raise again here the concept of the single member fund, and that is that you can add that second director as trustee of the fund who's not a member. So it's kind of alternate in that it's somebody who's there to ensure situation is sorted out if an event occurs to somebody. And the fact that it's somebody that's engaged in the fund from day one or from early on probably gives them a greater appreciation for the fund's investment strategy, those other elements associated with it. And disqualified persons. Now, disqualified persons, I'm about to touch on what, from a definition point of view, we're addressing here. But where you've got these alternate trustee rules, they don't apply for disqualified persons. So you cannot appoint your legal personal representative if somebody's disqualified. You've effectively got two options. Option one is you appoint the small APRA fund trustee. right? So we appoint the small APRA fund trustee, or we roll the member out of the self-managed superannuation fund. So I think that these are things that that we need to be mindful of. I just note that we did get another question. I'll read this one out, Carl, if you don't mind. Is trustee documentation required for the minor, or is it enough for just one trustee declaration to be done by the parent, i.e. do they need to do one in their own right and one as the LPR? That's a really good question. So it's one of those practicalities. So what we understand here is you're going to get different opinions on a lot of these things. So you could go to multiple presentations and get multiple answers to it. But I try to look at these things from a practical sense. So in the ultimate practical sense, the more documentation you can provide, the better it is. Okay, now legally, if you're under the age of 18, you can open a bank account. You can do all of the necessary things to operate as a human being. As such, you just can't act as a trustee. So I would be requesting firstly that the member sign their own member application, right? So that they are signing that. Now, whether you get the parent to acknowledge that signatory on the same document, I think that's something to contemplate there. Then as far as the consent to act as trustee, I think what you do in that sense is that you would prepare the necessary minutes, right? So I think you prepare a minute to state that that such and such, as in my circumstances, my son Nick, he's 17 years of age, right? So if he joins my self-managed superannuation fund, I can get him to sign an application. He's followed his dad in, just sign your name in cursive. That's kind of how we do signatures in the Miller household. And so he would sign that application to be a fund member. I've already consented to act as trustee of my fund, so I don't need to consent to act as trustee again, but I think it's important to have an acknowledgement, a trustee acknowledgement, that in the instance of appointing Nick or Nick being a member of the fund, that the trustee acknowledges that Tim Miller, as trustee, is acting in his capacity and also the capacity on behalf of Nick. So I would say that one consent to act, one trustee declaration are enough in those set of circumstances. The child doesn't need to then sign until they turn 18, and then at that point in time, they've got all those additional responsibilities to take into consideration. So where I would get to next then is with regards to the rule of may, which I say that the trustees may act in the fund, or an alternate may act in place of the trustee, eventually becomes a rule of must. So my rule of must is that if you want to satisfy the definition of a self-managed super fund, we can all talk about, well, you don't have to appoint a legal person or representative, but ultimately you have to do something at a point in time. And the shortest point in time, or really ultimately the longest point of time is 6 months. The shortest point of time is going to be almost potentially immediately if a death benefit is paid out relatively quickly in the SMSF space. And at that point in time, you would have to look at removing someone and then using your 6-month rule to make appointments. So when we talk about whether someone has to be appointed, okay, we can contemplate the rights and wrongs of that. But ultimately, to meet the definition of self-managed super fund, something must occur. Now, whether that's just that you become a sole director, corporate trustee, notifying ASIC, doing all those sorts of things, they become relevant to the situation. So, look, let's move on to disqualified parties, and then see just a quick check. Any questions coming in while I was giving that explanation, Carl?
We do have one more question here.
Okay.
So. Again, on that same alternative trustees, if a member does not have an LPR or an EPOA and didn't set up a valid binding death benefit nomination, who can be the alternative trustee?
That's a really good question. I guess it's whoever understands superannuation law the most and runs to the fund and takes over that role. Now, that's a flippant kind of answer. But it's the risk that you take where if the fund has a single member and let's say it's a single member with a sole director company, because if you've got 2 members, you've already got another trustee. So you've at least got somebody, what we like to say, holding the checkbook, right? So you've got somebody who's there to be able to make decisions, and that's quite legitimate for a remaining or surviving trustee/member to make decisions on the fund. But if you've got a sole director company, right, and that person has not got an enduring power of attorney, does not have a legal personal representative, well, then the first question you've got to ask is, they clearly also don't have an advisor, right? They clearly have no other relationship with any other professional, because they have not been advised appropriately as to how to do in this situation. But they run the risk that the fund will fail the definition, right? So if they die and no death benefit is paid out, or something occurs, or they lose capacity and no actions occur, well, that fund has to lodge its returns. So at some point in time, the tax office is going to come knocking and say, you haven't lodged your return, what's going on? Then there's silence, because there's wall of silence, because there's been a death or a disablement. And so the ATO would probably at that point in time step in and appoint an approved trustee. So, you're going to get to a situation where ultimately having an LPR and an EPOA is what you need to do to ensure that the ATO don't come along and appoint a trustee at a later point in time. But that is ultimately what may occur to get a fund through a sticky set of situations. So something to be mindful of in that regard. So moving on to disqualified persons. So clearly we're talking about somebody who has a relatively bad track record here. And it's important to understand this. I've got numerous examples that I can raise, and I'm going to touch on a couple of them with us here, or with you all here. But somebody that's been convicted of an offence involving dishonest conduct. Now, dishonest conduct in itself is a relatively difficult concept to understand in the sense of an SMSF, because it's ultimately around dishonest conduct with links to financial management and decision making. So your offences around fraud, theft, and those sorts of areas are far more relevant than traffic infringements and other things. So you've got this idea of clients and trustees who maybe do the wrong thing, but they don't necessarily meet the automatic definition of a disqualified person. But then you've got to you work your way through, and have they been subject to a civil penalty imposed under SIS? So have they been in breach of one of the other legislative restrictions? Now again, the answer to that might be no. Are they insolvent under administration? So are they an undischarged bankrupt? And I know you've got one that you want to raise in a moment there, Carl. But alternatively, have they been disqualified from acting as trustee by the regulator? And the tax office have this capacity to remove somebody because they deem them not to be a fit and proper person. Now, that fit and proper person, again, you read through the text from the regulator on that, they've got to go through a whole heap of steps, and it's going to look at standing in the public. It's going to be, what sort of work you were performing, what sort of circumstances arose to the charges, and all those sorts of things to make the determination. And I can honestly say that I've never seen a trustee removed under that fit and proper person position based on a regulatory decision. And I've seen some pretty terrible trustees. And that's to suggest that I've seen some convicted of offences that we would all think are abhorrent in what they've done. But because it wasn't related to their finances, the tax office have come back to us and said, well, our hands are tied. They can be trustee of the self-managed superannuation fund. Now, interestingly enough, or thankfully enough, because of these charges in this particular instance of the fund that I was dealing with, because they were imprisoned, they also then faced financial ruin, which of course then deemed them bankrupt. So, it came around to getting them disqualified, but it's one of those situations that it's not immediate that if you get charged with something that you're going to be disqualified. And of course, the other thing is too, that if you are convicted of a dishonest conduct event, then there's dishonest conduct and there's serious dishonest conduct. And if it's not serious in the sense of the penalty, then you can apply for a waiver to your disqualified status. However, if it is serious, so you are sentenced to 2 years in jail, or you are fined 120 penalty units, which is only $26,000. But if you find that amount, then you can never be trustee of a self-managed superannuation fund. And so, you need to be mindful of those circumstances. But Carl, you had an interesting one that you were telling me about with regards to bankruptcy before.
Yeah, we did. So recently we've taken over a fund that's transferred over to us. And when we were going to access the ATO portal and appoint ourselves as the tax agent, we've noticed that we can't actually get access there with the ATO. So we've done our investigations with the ATO, trying to follow up what's happening, why can't we get access? We actually found out the trustee has been disqualified and bankrupt for 3 years.
Right.
So we were speaking to the ATO, trying to find out what we can do to rectify this issue and get access. Given that the client was actually close to ending their 3 years of bankruptcy, the ATO allowed us to move forwards after that date had lapsed, which wasn't far off, luckily.
Right. Okay. Look, so that's an interesting one because, I mean, the general rule of thumb is you go, okay, if you're made bankrupt, here's a list of things to do. Yep. Right. First thing is, well, maybe not the first thing, but one of the first things is, do I have a self-managed super fund? Yep. I need to act accordingly. So clearly that was really low on their list of things to do, and they maybe never. And we've all got lists, and we don't always get to the bottom of that list, but clearly they didn't get to the bottom of the list. But interesting out of that is that the tax office effectively sort of, I use this term very loosely, gave them a get out of jail free card, in that they said, okay, well, you've served your term. The fund, we're a little bit indifferent to it, but you're no longer bankrupt. You've been discharged from bankruptcy, so you can now continue on. And I guess that makes sense, given that the ATO's position is we want to protect your super. And if nothing had gone wrong with the fund over that 3-year period, and they'd lodged and done all that sort of stuff, remarkable that the ATO didn't pick it up earlier about the bankruptcy bit. And again, maybe there was an oversight, a regular or an administrative oversight there for them not to be notified. And I would have thought that maybe they did or should have picked that up earlier. But yeah, interesting to know that we communicated with the ATO and therefore got a resolution that was satisfactory to everybody, which I think is better to the sweep it under the rug approach that a lot of trustees try to take with regards to some of these issues. And of course, part of all this is that you've got the annual declaration, the initial declaration, and goes back to a little bit of that question before, that you've got to consent to act as trustee of your self-managed super fund, but you also then have to declare that you are not a disqualified person. Now, depending on how you prepare your financial statements, there's a trustee declaration each year as part of those financial statements. And the declaration may state, may have a statement to the effect that you continue to declare that you're not a disqualified person, or it may just state something as simple as the trustees continue to operate in accordance with the SIS Act. And of course, if you're operating in accordance with the SIS Act, then you're operating in accordance with the disqualified persons sections, and the fund is going to be okay under those sorts of circumstances. So all those sorts of things become fairly relevant. So look, this is sort of my summary page with regards to the key issues around the various appointments and removals. Then we'll get into a couple more of the practical issues and a couple of examples as well to contemplate. But firstly, if we're talking about the death of a member, so we need to understand what the conditions of appointment are under both the deed and under the constitution if they've got a corporate trustee. And I think that's pretty critical. I know through my experiences that you get a lot of deeds that are, I guess, questionable in the way they address the death of a member and the appointment of trustees. And it may make a comment along the lines of that membership ceases upon the death of the member. Now, we know that can be problematic because if you're not a member, then the whole capacity to appoint a trustee in place of the member doesn't work because you're not replaced. There's no member to replace. Now, you've also got other definitional issues there. So understanding how the deed works is fairly critical. The appointment of the LPR is from death to the commencement of the benefit payment. So again, I pose this question to yourself, Carl. How long does it take to pay a death benefit?
Well, Tim, to quote yourself,
yeah.
How long is a piece of string?
Yeah.
We'd generally be talking years in some instances.
Yeah. Look, and this is the thing. I mean, you know, reversionary pensions, well, they're payable from day one, right? You know, but how many pensions out there do we not know if they're reversionary or not, because they were set up probably before 2007. You know, on the sniff of an oily rag. You know, a one-page trustee resolution where mum and dad think it's reversionary, but nobody else knows whether it's reversionary or not. And you know, so documentation is so critical in these processes. But like you say, the death benefit, the LPR is appointed from date of death up until the death benefit commences to be paid. Now, if it's questionable how the death benefit is going to be paid, that period could extend out for a significant period of time. I think I've told people, and many of you that have listened to my presentations in the past would have heard about the 7-year death benefit that I was involved with. Well, I think, you know, that's a little bit of storytelling, a bit of poetic license in the length of a death benefit, but it was certainly over multiple years that it took to pay the benefit out. And so therefore you've got the LPR appointment up for a long period. But contrary to that is this terminology from death till the commencement of the payment of the death benefit. Now we know that from a lump sum point of view, that you can pay an interim and a final death benefit. So the circumstances where somebody is appointed and you pay out a nominal amount, you know, maybe to help with funeral expenses or do something else like that, well, that's when the death benefit has commenced to be paid. Now, that means the LPR has to be removed from that point in time, or in theory, from a legislative point of view, should be removed from that point in time. So it can be problematic. So all of these sorts of issues are things that we need to be considerate of. And then, of course, and this is reflective in a lot of these areas, the removal contingency. So you've got the 6-month rule, and that is that once the LPR has been removed as the trustee of the fund, then a fund retains its definition of a self-managed super fund for 6 months. So you've got that time frame to fix up the situation. Of course, that's where if you've got a corporate trustee and you went from 2 directors to 1, you're going to satisfy that automatically. So you've got those sorts of things to consider. With the LPR, again, you want to look at what your conditions are around appointments from a deed point of view and from a constitution point of view. What sort of conditional powers? Now, this is more about, and I've kind of latched this into here, but from a trustee point of view, we need to be mindful of there are differences of how EPOAs are treated. Because normally from an enduring power of attorney, it's going to limit somebody's power to act on behalf of somebody with regards to financial matters, health matters, and all those sorts of issues. And so any conditions that you want to put on capacity for your EPOA to make binding nominations and all those sorts of things, they have to be written into the terms of the EPOA. However, the trusteeship part is primarily based around, do you have an EPOA? And if you have an EPOA, then that person can not act on your behalf, but they will act in your place, right? So understanding how that operates, and then they will be operating under the normal trustee covenants as any other party would. If somebody's the LPR due to a legal disability, then what's the duration of that legal disability, right? And as we talked about with the example before, is it an associated party? Do they know a lot more about them, or are they a professional appointment? So what's the responsibility, and how does it work? And what are the alternative arrangements if that person can no longer act? Now, the whole LPR and legal disability, and again, it's just an opportunity for me to raise an example I had a number of years ago. We had a situation of a husband and wife self-managed superannuation fund, both in pension phase. So they were starting to get to that point where they were enjoying their overseas holidays and doing all those sorts of things back in the days when we were allowed to do overseas holidays. And the wife noticed that her husband's spending habits on this trip were, let's just suggest, not his usual spending habits. So he was far more, well, let's just say his wallet was open a lot more, and the funds flew freely, and that concerned her because he'd never been like that. And when they came back to Australia, his advisor noticed as well the condition that he was wanting to spend more money and do things, and so it raised a little bit of concern for the spouse. And so they actually raised this issue with us and said, look, we've actually been to the doctors and he's been diagnosed as bipolar. Now, what that triggered was a situation where from a medical point of view, they said that he didn't have the capacity to act as trustee of his self-managed superannuation fund. Now, he heavily disputed that, right? Despite the fact that obviously he was, had changing in spending behaviours and all those sorts of things. And so his wife, effectively, he didn't have the capacity to make a decision. So as the members, they decided to remove him. She didn't want the full responsibility, so they actually appointed their son. But because they didn't want to appoint him, even though the son was the joint EPOA with the mum, they didn't want to appoint him under the EPOA, so they brought him in as a member of the fund as well. And effectively, she operated under the EPOA, so she had dual capacity, and then the son came in. So you had 3 members and 3 decision makers, albeit that one of the decision makers was the same person. Now, this was really problematic because the husband still had varying levels of capacity, and he was very argumentative about his removal as trustee. And so on a very regular basis would come in and with a letter and say, I'd like to reappoint myself as trustee of the self-managed superannuation fund. And each instance, we would have to go through the process of saying, okay, once you've got the medical clearance, so you give us the medical clearance that says you've got the capacity to do this, then we will reappoint you as trustee of the fund. But, appointing other parties can be problematic, particularly if capacity is questionable. And so it's something to be mindful of there. And so parent guardian, again, similar sort of situation. What are the administrative obligations? Understanding that once somebody turns 18, then they're an adult and they need to be trustee of the fund. And if you've gone down the individual trustee path, then you're going to have to change all your assets and all those other elements. Whereas if you've got the corporate trustee, you can just add them as a director. But also, where do you sit in the whole? It's a little bit like the 6-member super fund thing, the liquidity of having children and adults in the same fund and different investment dynamics as such. So all things to be mindful of. I wanted to touch on the enduring power of attorney element before sort of finishing off with a couple of, I guess, worked examples, or not worked examples, but I guess scenarios that we've had to deal with in these circumstances. But just to reiterate the enduring power of attorney point, it does actually, and this SMSF ruling 2010/2, it was a really good one coming in the day when it did, because again, what's interesting to note all along, and I think many of us are waiting with bated breath on the LCR about non-arm's length income, just the fact that the ATO from draft to finalisation often will change the terms, and in the draft ruling for enduring powers of attorney and the appointment of alternate trustees, they were very clear that you couldn't that trusteeship you couldn't pick and choose as far as multiple trustees. So if you had multiple attorneys, you could only pick one, right? So where we finalised, where we got to in the finishing point, is if you have multiple attorneys, then you can appoint multiple or single replacements. Right? Now, the enduring power of attorney is going to dictate how you make that decision, because is the power of attorney made jointly, which means if you've got 2 attorneys, then all decisions have to be agreed upon by both parties. Now, they can jointly agree for one of them to be appointed as trustee of the fund. Is it severally, which means either can make a decision, or is it jointly and severally? So can either of them make a decision, or can both of them make a decision? So as I said, you don't have to appoint all of the attorneys, but equally you can. And so it's one of those key issues of, are people happy in that set of circumstances with that? Was that another question that just popped up there?
We do have another question that has popped up. So this question has come in. I once read that in case on individual trustees, where there is a change in trustees, the law does not state that the names of all assets need to be changed. Is this true? And can you give me a reference point?
Right. No, I can't give you a reference point, not off the top of my head. But I think what we need to understand there, and it's something I certainly am keen to look into. But what we need to understand there is that the trustee or the assets should, and let's be clear there, should represent the name of the trustees of the superannuation fund, and obviously the assets must be maintained separately from personal assets. So if you've got assets in individual names, then those assets should be clearly identified as assets representing assets of the trustee of the fund. So you've got the whole separation of assets covenant that you need to be mindful of, and the supporting regulations. Then as far as the requirement from, the trusteeship or the assets should actually reflect what the trustees of the fund are, that's more of an administrative issue in that it's a true recognition or representation of the status for the superannuation fund. And if I sort of throw that into an example, and I said I'm keen to investigate this a little bit further afterwards, but if we take that as an example, if you've got individual trustees and one of those trustees is removed, right, but you don't actually change the assets of the fund over, and you retain that individual's name on the assets, and then something happens to the fund, well, what happens if that individual comes back and says, well, actually, that's my asset? And so it all of a sudden creates this potential legal claim that the asset is in the name of that other individual, and therefore they will say that they were holding that asset on trust for themselves or partly for themselves, despite whether that's a truth or not, because not everybody operates under the scope of truth. And it can create an ongoing legal battle for the superannuation fund. But I want to take that question on notice, and I will certainly have a bit of a look into that from a point of view. So having an EPOA does require an actual cessation, and then it does actually require the appointment. So as I said, it's in your own right. So you remove the existing trustee and you appoint somebody else in that party. So it can be an existing member, and going back to that original question earlier with regards to the children being appointed, if you appoint an existing member, they're not necessarily having to consent and to act as trustee again. But if they were originally appointed before 2007 and then they're appointed as a trustee post 2007, then I think arguably there is a requirement for them to complete a trustee declaration. So all new trustees appointed after the 1st of July 2007 must sign a trustee declaration. So I think there's that issue there. But I wanted to highlight, and this is that reference point between, say, death and disablement. Dawson versus Dawson, which was a situation where husband in his second marriage had appointed his son as his enduring power of attorney. So his son from his first marriage is enduring power of attorney, but then had his son-in-law as his executor of his estate. Now, he appointed his first son as trustee of the fund in his place because of his capacity to act. And so the son was actually appointed, and then the dad died. So the new wife and her son argued that the original son should be removed and the son-in-law appointed as trustee. But the courts determined that the original son was appointed legitimately and there was no scope to make him resign as trustee of the fund. And so it does create a situation where you want to make sure that there's at least some form of understanding, whether it's scoped by the deed or whatever else it might be, to ensure that there is a natural flow of trustees. Because yes, you might fail the definition of an SMSF at some point in time, but once somebody's appointed, they're appointed. Unless it's under that death clause, which requires them to be removed there, then that appointment could be permanent and it could create problems for the fund. So again, having multiple EPOAs, having different executors in that, it's not uncommon. It's going to be problematic for people to be mindful of. So what can go wrong? Relationship breakdown can go wrong, most certainly. Loss of mental capacity, clearly overseas deployment, business failures, and death. These are all the sets of circumstances where we can see issues going wrong in self-managed superannuation funds, and I think that we need to be mindful of. So it's really critical for us to plan ahead in these circumstances and be prepared for it. And I know, again, just to jump to an existing client of ours that we were discussing before, you had a question with regards to an overseas, a comment in regards to an overseas client, Carl?
Yeah, so we've got an existing client here who is overseas. Obviously, with what's come out of last year with COVID and travel restrictions, Their plans to return to Australia, they've now put on hold, and they are now looking at staying overseas permanently. So just interested to hear your comments on that.
Yeah, so that's an interesting one, because again, the whole definition of an Australian super fund and that central management and control, and we had the question earlier in the presentation. Central management and control is probably the key thing versus the active member test, because it's easy to say don't contribute, right? But it's not easy to say don't make decisions on behalf of the fund. And so if you've got control of the fund sitting overseas, then one of the things to be mindful of is that, have you got at least 50% here? So if it's permanently overseas, right? If this client's going to move permanently overseas, does he have somebody who can join the fund here and act as trustee? So you've got the 50-50 rule. I don't know if in the situation, if there is anyone in Australia.
Yeah, so we have got the son in Australia,
right?
The son of the couple.
Yep.
So not an active member.
Yeah, okay. So again, it's a matter of looking at that and going, okay, well, if there's a son, they're not the active member or not a member, would they be willing to join? Would one of the parents be willing to give an EPOA to the son? You don't know what the relationship's like in that sort of circumstances. So then would they look at appointing somebody else to act as an enduring power of attorney? Then what are they going to go through with the witnessing requirements? And it's going to be a matter of looking at each state's requirements as to what you can and can't do. So, by planning ahead, and of course, in this situation, if this client was previously satisfying the conditions, it's very hard to plan ahead if you change your plans. And so a change of plans can result in a change of circumstance, which can create problems for superannuation fund. And, the same thing can apply. We were talking about, particularly if we look at expansion to 6-member funds, or even just multi-member funds, and relationship breakdowns, and the introduction of non-member spouses. It all even comes down to the decision-making process of the fund, because a relationship breakdown, it might be the first point in a transaction, not a transaction, in a life event. But then, how long does separation take, and at what point does separation become divorce, for example, or legal recognition that you're no longer in a relationship? And what is the impact of the fund from a trusteeship point of view, given that those parties are all trustees throughout those circumstances and still have the capacity to make decisions? So, identifying all of those issues is a key step. And one of the things that I always come back to is that trusteeship is a singular concept. And the reason I put that there, and clearly, who's steering the ship, who's pushing who, is that might be how you operate. And if that's how you operate, then should you be in the same fund together? Because, the inability for decisions to be made, and we can talk about trusteeship decision or directorship decision based on shareholdings, and we can talk about it based on member balances and all those sorts of things. But the trust concept is a trust is a trust, and trustees is singular. So you need to be able to agree on decisions for the fund to be able to move forward. Otherwise, you can end yourself in a bit of a stalemate. And I think the point of it all is, sort of as I summarise the key issues, is that everybody has some form of a story to tell, and so alternate trustees become relevant to funds. And so, whether it's entering into a relationship and bringing that person into the fund, whether it's raising children and bringing them into the fund, not so much the dog can't be a trustee of a self-managed super fund, but then, what happens in the event that the relationship breaks down, and what's the impact that has. Traveling, are you traveling permanently like this client? Is it short-term in its nature? What is the impact of it? Do your business failings lead to debt that leads to bankruptcy? I mean, how often do you hear people talk about saying an easy solution for your business problems is to declare bankruptcy, but then it creates other issues for the fund. And then, of course, invalidity and death. They're probably the two that we talk about the most with regards to alternate trustees, but they are effectively around the corner for every fund, and that's, don't we wish to bring that upon every fund and go, okay, everybody's going to pass away, but that's the inevitability of life, and we need to be prepared for that. So to summarise, I guess these key points is that we need to read our deed. If you've got a corporate trustee, then you need to act with ASIC in a relatively short time frame. So if there's appointments or removals to be made, it needs to be done within 28 days. And ASIC are pretty good at finding you, right? ASIC like a good fine, and they're very keen to dish them out. And I know that if you are removing a director because they have died and you do it outside the 28 days, then they do have an element of relief that they'll provide, but you need to apply for that. You need to identify that the person has passed away, and then they will waive those fees occasionally. You know, I've certainly worked in those operations where they've been waived. Similarly with the ATO, you need to do your notification of changes to the trusteeship within 28 days of those events occurring. They're not as forthcoming with fees and late charges and all those sorts of things, because they don't have costs associated with that. So it works a little bit better in that regard. If you are disqualified, then you need to notify the ATO immediately. Again, I had a situation where a client who was disqualified, they did notify the ATO immediately, but they were still a member of the fund 18 months later because they were trying to sell property to be able to pay their benefits out. Now, in all sense of the world, that fails the definition of self-managed superannuation fund. But the key to that transaction was communication and talking with the regulator about why they were still a member of the superannuation fund. And the 6-member or the 6-month rule doesn't apply to new membership. So in most circumstances, you've got 6 months to fix things. But if you're adding a new member, other than under non-member spouse and separation, then you've got that 6-month period. But adding a new member, you don't have that, and you've got to act straight away. And of course, all trustees must declare that they're not disqualified, and also that they consent to act. So that's one of the key things. It's not just that your LPR is going to be the trustee, it's that they have accepted that responsibility and will take on the role as trustee and are appointed accordingly. So we need to be mindful there. So to finish it off, small APRA funds, not talked about enough, but in certain circumstances, I think they are still a very viable option, and people need to be considerate of them as an option. That not all circumstances require the appointment of a non-member party. So you may be able to appoint the existing member of the fund to operate as a legal personal representative, and that may just assist in the fund continuing on without too many problems. And also, is there an easier, better way to address the situation? And I think the overseas residency is one of those scenarios. Is it easier to appoint an enduring power of attorney, or is it better to appoint another member of the fund so that you can retain the decision-making ability, but it's a 50-50 decision-making capacity? So, you know, have someone in Australia who's got a dollar in a fund, but is in the conversation with the decisions being made. Is that easier than actually going and appointing somebody to replace you as trustee of the superannuation fund? So look, that's a quick fire run through of alternate trustees and trustee-based events. Thank you all for your attendance today. Have we got, Carl, any other questions that I've missed as we've gone through the presentation?
No, I think we have covered everything that's been raised.